All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmera, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for the Flood Disclosure Strike Back, new rules for landlords, mobile home parks, and condos. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. The training is being recorded, so if you registered, you're going to receive an email with a copy of the recording and a link to the materials, the CLE code. All of this is going to be posted on YouTube as well. So you're going to be able to find the CLE code, the materials, everything on YouTube as well if you didn't have a chance to register. The training was approved by the Florida Bar for one general CLE, one real estate certification credit, and one condominium and plan development law certification credit. So as I said, I will announce the CLE code towards the end of the presentation. I will drop it into the chat, and it will also be included in the email that goes out from Zoom within 24 hours, and it will also be on the YouTube description as well. So closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. For questions, we're gonna leave the questions towards the end. The presentation is really structured, so feel free to use the Q&A feature. Drop your questions there, and towards the end, we can use that to track the questions and answer the questions. But please hold those questions towards the end, and even towards the end, if you want to come off mute, you can raise your hand, and I can bring you off mute if it makes it a little bit easier. The training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with it, I'm going to drop the link for PILS into the chat, and it will also include a lot of information about pills in the email and the YouTube description as well. Now, I need to do a quick plug for a few other organizations. We have the Housing Umbrella Group, or HUG. So if you're a civil legal aid attorney or paralegal or advocate that handles any type of housing work, I highly encourage you to join the Housing Umbrella Group. To join, all you have to do is email me and let me know that you want to join HUG, and I can set that up for you. Another group that you should definitely consider joining if you're a civil legal aid and you're doing disaster work is the Disaster Umbrella Group, or DUG. Our speakers today, Jason and John, are really active in that group. This is one of those groups that really leads by example when it comes to, how do we as legal aid organizations across the state collaborate and work as a community to better serve our clients. So I'm not gonna do the full-blown speaker bios because I want to save as much time as possible. In the materials, you will see both Jason's and John's full bio. But with that said, I want to pass it over to Jason and John with Bay Area Legal Services. The floor is yours.
Thank you very much, Jorge. Good morning, everyone. My name is Jason Susalla, and I'm the managing attorney of Bay Area Legal Services Disaster Relief Team. And I am joined here by my coworker, John Lawless. Introduce yourself.
Hi, everybody. I'm John Lawless. As you can see, I'm a senior staff attorney at the Bay Area Legal Services Disaster Relief.
All right. Thank you, John. So thank you for giving us some of your time today. We're here to discuss flood disclosures. This is really a part 2 of our flood disclosure presentation from last year at about the same time. John, if you would advance the slide, please. Thank you. We're going to start off with just giving a roadmap of what we're expecting to discuss here today and what information we would love to impart upon you. So first off, generally the basis of the flood disclosures that we are here to talk about will be Florida real estate disclosure laws, and basically the updates from the law from last year that took effect in October 1st of 2024. Going over some of the recaps there about what that law really changed in the state and what the changes are coming up here on October 1st of 2025. We're going to do a recap on those items from then, go over some of the protections that it affords, the disclosures that are required, and the remedies that are available to folks who are either buying properties, renters, mobile home owners, or purchasers of folks purchasing condos. Finally, too, we're going to go over some practical aspects of what this is going to look like in the end. There are a lot of question marks because, again, this law has yet to take effect. It is brand new as of October 1st, 2025. So while we have analyzed what we see in the statutes, it's going to be a bit of a question of how some of this will play out. So we will give our best guess sort of about what areas will be developing as we go through this. John, if you go forward, please. So actually, John, why don't you go ahead and recap what we did last year,
All right, sure thing. For anybody who's not familiar with this, this is like we said, this is part two of a flood disclosure CLE that we had done last year. So we're gonna go through and sort of do a quick refresher. The full one is available if you want to take a look at that. First thing I want to say on that is I honestly am so happy to be here doing this flood disclosure CLE not less than a week after a major hurricane hit us. So good news there. Already off to a great start. The basic framework prior to any of the disclosure laws that really we're going to talk about today was a case, if you're not familiar with it, Johnson v. Davis. That really kind of set the standard for general real estate disclosures in the state of Florida. The central holding of it there, I mean, obviously there's a lot more to it, is right here on the screen. It's basically that if you are a seller of a home and you know of a material defect in the property that's not readily observable to the buyer, you do have a duty to disclose that. And that's just sort of as everyone probably realizes, the real default rule is caveat emptor, buyer beware. So if there is a readily observable defect in the property, you don't actually even have to disclose that. Johnson v. Davis really just kind of stepped in to move that into making it safer for buyers, so that sellers had to actually make some sort of baseline disclosure for something that you may not be able to readily see. And the real question kind of had been whether or not flooding was one of those things, because obviously there are flood maps that are available. You can see if you're in a special flood hazard area, again, a lot of which was detailed in the prior CLE. So if you have some curiosity about that, feel free to take a look at that. I did add here too just an example citation to the Smith v. Lynch. That's actually a second district case from earlier this year. If you're familiar with the area that we're in, particularly in Pinellas County, it's right out of Shore Acres, dealing with routine flooding there. And this is a good way to take a look at the modern application of Johnson v. Davis to the specific context of flooding. So it's still applicable, still get a lot of use out of it, particularly because these disclosure laws came into effect in 2024 and next week respectively. So a lot of sales that took place before that are still going to be under this scheme. So a good thing to be aware of. And just because these new laws are in effect doesn't mean that we can't still use this as a tool. So it's a good thing to be aware of. If you're not familiar with it, go take a look at the case. The other new thing is last year, the Florida legislature introduced 689.302. And that actually required a specific disclosure when you're selling a property, going through whether or not the seller was aware of any insurance claims that had been made for flood, and whether or not they had received any federal assistance, including but not limited to FEMA. And that was kind of a big deal because that was not something that had to be specifically disclosed. One of the biggest reasons that was important is because, routine flooding, obviously that's going to be covered pretty expressly by Johnson v. Davis. But for these events where, you're not going to see flooding for years on end, 10, 20 years before you see another event. But there was a flood, there was previous need for insurance, or in particular FEMA. That wasn't something that had to be disclosed, so this kind of addressed that. Why that's important, I'll get to on the next slide. But the other important thing is, for renters and people buying from developers and condos, mobile home parks, what the disclosure schema was really not much of anything at all. If you weren't actually buying the property, there wasn't a whole lot that they had to give you. Fortunately, what we're going to see in this upcoming presentation goes a long way to solve that issue. As I've mentioned before, the first thing I'll say here is if you are curious about 689.302 and what it would look like last year, there is an excellent presentation that was given by a couple of, as I say, handsome men that you can take a look at that link. I know it's kind of a jumble. This will be sent out afterwards, so feel free to copy that and take a look. I already mentioned a little bit the 24 edition of 689.302 created that specific disclosure. We were relying on Johnson the entire time prior to that. Well, prior to Johnson, we were under caveat emptor. Johnson in 85 kind of changed that whole scheme, which is a good thing for home buyers. The reason that is so particularly important are these last two items you'll see on this slide. And these are the regulations relating to FEMA relief, NFIP, and what happens when you get a flood and get federal assistance. If it is your first time requesting federal assistance after you're flooding because you have inadequate or no flood insurance, FEMA typically, if you can justify the loss, will help you. What they will do after they help you is they will require you to purchase flood insurance, at least at the amount of the loss, and maintain that on the property forever. If that property subsequently floods, and you try to request FEMA assistance, they're not going to give it to you a second time, unless you had maintained flood insurance and your flood losses exceed the insurance. Not going to get too into the weeds on that. Happy to talk about it somewhere else if you're interested. But the idea is, if a seller, for instance, 20 years ago, got FEMA assistance for one flood and it wasn't regularly flooding since that, did not disclose that to the buyer, and the buyer then, without knowledge and didn't maintain flood insurance, went to FEMA, they weren't going to be able to get FEMA assistance because they had no idea. And this disclosure from 689.302 really closes that gap. And that was kind of the big deal with that. That, I think, is pretty much where we wanted to get in terms of a summary on what happened last time. So, oh, yeah, you're right. I did. I wrote this thing. Thank you for actually paying attention to what I did.
You're
Jason.
welcome, John.
Yep. Keep yourself muted, Jason. Maintain the illusion that we're not sitting 2 feet from each other.
Just do your work.
Thanks, Jason. All right. So the remedy under 689.302 ends up being a little bit limited. And the reason for that is, if you discover it prior to the sale, that's great news. You have the right to rescind. And if any expected reliance damages, anything like that, that you incurred prior to the sale in anticipation of the sale as a result of not getting that disclosure, you're good to go. Subsequent to the sale, obviously you have a cause of action against your seller for failing to make the disclosure. And if you discover that quickly enough, that might get you somewhere. The problem really comes into play when you have a disclosure that wasn't made. Years go by before a flood event takes place. You then discover that the disclosure wasn't properly made. Those sellers, maybe you can find them. Most likely not in a lot of circumstances. They can be difficult. What if they left the state? What if they're not available? What if they died? If they are available and they took that money from the sale, typically a lot of the times what you do for the sale is you buy a new house, particularly if they were in Florida. That's going to be a homesteaded house. So you can get a paper judgment against them, but actually recovering your losses can be a difficult thing. So it can be difficult to enforce long-term, at least, at those disclosures under 689.302. So it creates more protection than there was. But there's still a little bit of a gap left there. We did discuss in that previous CLE some of the things we thought about solving that, but that's where we are. Now, what we were left hanging on, even with that prior disclosure, was, what if you're a renter that gets flooded? What if you're a mobile homeowner that gets flooded? And you find out after the fact that this was prone to flooding and you have a loss. What's your remedy against the person who didn't disclose it to you there? And the answer was not a tremendous amount, honestly. And then again, as I mentioned, the lack of availability of FEMA assistance prior to the undisclosed receipt of FEMA assistance at that same property. Again, because that ties to the property and not to the person when we're talking about homeowners, different when it comes to renters, then you might be out in the cold as well. So those were some significant gaps that were left open. That gap is still kind of open, that last one, but we are at least going to be able to address with these new disclosures, renter and mobile home owner remedies. So now I think I'm really ready to go on to our new stuff, and I will hand it back over to Jason.
Thank you, John. So let's start off with additions to 689.302. What's going on here? Let's talk about the new stuff as of October 1st, of course. So again, we're talking about the sale here of real property, as in, what previously were the disclosures here. The bill is seeking to add additional disclosure items to the sale of real property. So primarily here, what we're looking at is this one addition right here, and I'll read it out. Seller has or has no knowledge of any flooding that has damaged the property during seller's ownership of the property. Generally, what we're looking at here is an expansion of the requirement of the seller to disclose their knowledge about whether or not that property has flooded before. This was not previously in the disclosure list under 689.302. So again, the questions were previously, did you get federal assistance? Did you get an insurance payout? No, no. Okay, well then I guess that's fine for the disclosure. But if the particular property owner or the seller there knew that the property was previously flooded and they didn't get assistance and they didn't get insurance, well, then they were okay to say no, and that property could pass even if it had flooded, right? And they had personal knowledge of that. So this is to sort of capture that overall idea that a seller is now obligated to disclose whether or not they have personal knowledge, just flat out if that property was subject to flooding before. Additionally, there's an expansion of the disclosure item here regarding assistance. It was previously noted that it was just for federal assistance. The term federal has been removed from this particular disclosure item. So again, if the particular seller has received assistance, not just federal, could be state, could be local, could be nonprofit, anything. Of course, there are a lot of different groups that provide assistance for flooding damage. They must disclose that as well. So again, this is a general expansion of the disclosure requirements for the sale of real property, trying to capture more areas in which there is knowledge of this flooding disclosure that must be passed along to a prospective buyer. So now moving on from real property, here are some of the new items included in the expansion of this flood disclosure law. We have a new law on 83-512 that is going to be covering renters. So this is in addition to Chapter 83, Part 2, the statutes governing landlord-tenant landlord-tenant leases in Florida. So now here what we're seeing is that in a situation where a prospective renter is looking to secure a lease for 1 year or more on a property, the landlord must provide a flood disclosure regarding that property. So this would not apply to, again, let's say month-to-month renters or things like that. But again, folks who are looking to enter into a lease, again, for 1 year or more, must be given a flood disclosure. In addition to the items that are included for the landlord to provide, there's a statement in there. And the statement indicates to the prospective renter that renter's insurance does not cover flood damage, and that flood damage must be covered by a separate flood insurance policy. So this is true for both homeowners, this is true for renters, and it's just a bit of an educational aspect of this flood disclosure that is to ensure that folks understand that if they're getting renter's insurance, that is not going to cover rising water damage. So again, there needs to be a separate policy if a renter wants to protect themselves from flood damage specifically. So here we have the basic form that's listed in statute. And again, note here that this says it must be substantially in this form. So there is some minor amount of deviation that is permitted when indicating this in the flood disclosure the landlord must provide. Number one, again, is just that new addition there that's been added in for the prospective home buyer. It also applies to landlords as well, whether or not they just have knowledge, period, of whether that property has been subject to flooding before. Number two, it's whether the landlord has received any insurance for flood damage on that property. They must disclose that as well. And it's not exclusive to the NFIP. It's just trying to cover any aspect of what an insurance payout related to flood would be, and that the landlord must disclose that. Number three, again, this is sort of incorporating the previous disclosure into this as well. Landlord must disclose if they've received any assistance for flood damage on that property, not exclusive to FEMA. Again, this can be state agencies, this can be local nonprofits, it can be a lot of different groups that can provide a flood assistance, and the landlord must disclose that. Number four, too, this is basically a definition of flooding, and it again is to ensure that a prospective renter understands the difference between, regular damage to their property that may be covered by a renter's insurance policy, and specifically damage caused by flooding. Again, when we're talking about water damage in generally, it's likely going to be by flooding. There are, of course, instances where if a roof gets ripped off of a particular structure, rain inundates the interior and damages personal property, that's a possible way that could be, damage could be covered by homeowner's insurance or renter's insurance, whatever it may be. But that's unlikely. And you see in here, basically any instance of rising water is considered flood damage, and that would be always covered under a separate flood insurance policy. There is a reference to rainfall in here, but it's not that the rainfall is causing the damage. It's that a particular area was inundated with rain and the water rises up. And again, that constitutes flood damage, which would only be covered under either a renter's flood insurance policy or, in talking about a homeowner's flood insurance policy. If you would advance. Actually, why don't you go ahead and take mobile home. I'm going to pass it over to John Lawless to go into some of the other disclosures for the other types of housing.
I'm muting myself. All right, just make sure you're muted. I don't want to hear you.
It's fine.
All right. Thank you, Jason. So you'll see taking a look at this, and don't worry, by the way, too much about, because I know these are slides that are just full of small print. So please don't worry about trying to scribble things down. This is all going to be provided, and honestly, this is really just a copy paste job from the Florida Legislature's website directly from the statute. So it's all out there. Don't worry about it. I just want to have it here so that we can take a look at it as we're going through. Like I said, first thing you'll notice is that this is pretty much a copy paste of the last one that we went through. Whether or not that's entirely appropriate, I kind of want to get into. The other thing I want to note too is you'll see at the beginning, still have to make the disclosure in a separate document. Also, interestingly, both for this and the landlord tenant statute, the flood disclosure must be made in substantially this form. You'll note in both the seller's disclosure and the upcoming disclosures we're going to see for condos and co-ops, it is not substantially in this following form. It is in this prescribed form. So there's a little bit of a difference there. A little bit more leeway, it looks like, for lessors on these disclosures. To what extent that is, I guess we'll see, because these are all new. First of all, you also see the same disclosure here with respect to the difference between renters insurance policies and renters flood insurance policies, just to let people know that you have that separate, or not necessarily obligation, but available form of insurance if you do want that stuff covered. One of the number one things that we saw in the aftermath, particularly of last year's storms, was people just being affected by that completely were not aware of the fact that renters insurance was also bifurcated into hazard and flood, just like homeowners insurance, even if they were aware of that distinction for homeowners insurance. So just practically speaking, getting this knowledge out there, it's a good thing. And then you'll see it said the park owner in this case has or has no knowledge of any flooding that has damaged the property during the park's ownership of the property. One of the problems that I have here is the wording of damage to property. As people who have dealt with this know, one of the reasons that mobile homes can be such a difficult thing to deal with after a disaster is that lot rent still comes due. And the reason for that is, doesn't matter if the mobile home was destroyed, the mobile home isn't the property that you're renting. The property that you're renting is a piece of land with a utility pole on it. So if that's not damaged, I'm not quite sure to the extent to which they actually expect this disclosure to be effective. Same thing goes for claims for insurance providers and assistance for flood damage properties. I think probably where we will see this for renters and assistance is not necessarily so much through FEMA, but more through like community development block grants through HUD. They have some programs available to help landlords actually get their property repaired so that they can then use, and then the exchange generally is that they use them for housing people who have been displaced, things like that. But that would count as a kind of assistance. Now, as Jason had mentioned previously too, that assistance doesn't have to be through FEMA. It just includes FEMA. So it can come from any other, state, local, nonprofit sources. That does have to be disclosed. So I think that's handy. And then it goes through the same thing that we did on the last one with respect to renters, what flooding consists of. So that's important just generally for the understanding of people who are renting in these properties. And a lot of the times, again, that we've seen in 2024 and in prior storms to some degree as well, just a lack of understanding among the general public as to exactly where that line is, what that means. So practically speaking, I think these are good disclosures to get out. That said, I'll go ahead and move on to I keep clicking off of one thing to the other. All right, there we go. And again, a big copy paste. So this is not a new statute. This is an addition to an existing statute for disclosures that are necessary when developers are selling condominium units. So you can go right through, gives that same disclosure up front that homeowners insurance policies themselves do not include coverage for flood. And then you have the same, again, you'll see a lot of these disclosures look very much the same. The developer has or has no knowledge that any of the property has been damaged during their ownership of the property. They have or have not filed a claim with an insurance provider relating to the flood damage of the property or the common elements, which is a difference here, and that's fairly critical. And also whether or not they've received the same assistance that we were talking about in all the property ones. And then goes on, of course, just like we've seen several times before, to define what flooding means. The other thing that the additions to this new bill to 7018.503 did was add a bunch of quotation marks to terms they had capitalized. Seriously, go ahead and take a look at it. SB 948 is a good way to Google it and take a look. Literally, they just added a bunch of quotation marks. All right, so now we're on to the exciting new information that we have to share about co-ops. As you can see, not a lot of changes. Even the 0.503 didn't change in terms of where the disclosures are, just because those statutes already mirror each other. But it is literally identical language. If you saw that transition, nothing changed. Same disclosures, same addition of quotation marks in this statute. But this is now a required disclosure in the context of a co-op in addition to a condo. And a lot of times co-ops, if you're not familiar with them, these do involve a lot of timeshares and things like that as well. So important to know that this is out there. Again, important for the general public to be aware of the fact that there is this distinction between homeowners insurance and flood insurance. So good stuff. But really, it's going to kind of come down to, well, they have to make these disclosures. That's great. More knowledge to the general public when they're making these purchases or they're engaging in these rentals. But now we kind of want to move into, practically speaking, what you do with that stuff. What are the remedies? What are the consequences for inadequately or failing to disclose any of that stuff? So we'll go ahead and start back with 83.512 and the violations there. Jason, you want to go ahead and take that one back over?
Sure. Thank you, John. Appreciate that. So yeah, let's talk a little bit about what happens if a landlord fails to disclose, properly disclose these flood disclosure items to a prospective renter. So in this case here, what it is afforded to a renter is they are allowed to terminate their active lease. So again, if they discover that there is a failure of that disclosure, the particular renter may go ahead and submit a notice to the landlord and terminate their lease and move off the property without obligations to pay any future rent. Further, just in general, again, if they have paid in advance and they move out during the payment period in which they've already paid for, the landlord must refund them that amount of rent over there. This does not, however, release a tenant who has had some unpaid rent from a previous term. This is not a get out of jail free card or anything like that. The tenant would still be obligated to make those payments. So all in all, what we're looking at here is, according to 83.512, the basic remedy is that a tenant may terminate their active lease term. So what triggers that exactly, right? And this is an area that we're going to be watching as it develops, because it says right here, substantial loss or damage to personal property. Now, what that constitutes, according to the statute, is that the personal property, the damage to it is 50% or more of its fair market value. Now, we don't know if that means if a particular tenant has damage to a single item, like an old radio, or they have to have damage of a certain threshold. That's not particularly clear. So again, the argument there is to be made that if any item is damaged and the damage to it exceeds 50% of its fair market value, such as maybe $5 for a $6 radio, whatever, that may trigger this particular protection for a tenant to therefore send a notice to terminate their lease term. This will be, like I said, a developing area. It's not particularly clear, so we'll have to kind of pay attention to see how this plays out in the court system about what is reasonable that actually triggers this protection to be afforded to a renter. You can move forward. What? Advances? What advance? I already said that. If they paid advance rent, they get. I said that already. You can say it later. You're fine. So 8363. This is something that became of particular importance and interest following Helene and Milton last year. This is already an existing statute under Chapter 83, Part 2 of Florida landlord-tenant law. And it affords tenants in situations where property they're living in receives substantial structural damage, they may, with notice, terminate their lease and move off the property. So again, this is a tenant-afforded right. This is not a two-way street. This is not something that's afforded to landlords. What we saw following Helene and Milton, and I'm getting off on a tangent here, was a lot of landlords attempting to use 8363 to terminate a tenant's lease on their unilaterally. And that's not permitted by law. Leases may have, force majeure clauses or other things like that. They're arguable that a landlord may terminate following a disaster. That's more debate otherwise. The point is here is 8363 is not a proper citation for a landlord to have authority to terminate a lease following structural damage to a property, not caused by the tenant, of course. That's another aspect here of this casualty damage provision, is that this is damage that is caused otherwise not by a tenant themselves. So 8363 is an important tool for tenants to be able to utilize, generally following a disaster where there's structural damage, and therefore they can, decide if they want to move off, they can terminate their active lease term and move immediately. There doesn't need to be a specific notice time or anything like that. So in situations here where, you have, we're still going to see exactly how 83512 will apply. 8363 will sort of work in tandem with that and supplement a tenant's rights to be able to terminate their leases, following particular sorts of damage. So 8363 does not require any sort of property damage, of course, or personal property damage, I should say, of a tenant. This is just rather whether the dwelling they're living in has received substantial damage. Similarly, 83512 does not require any structural damage. So they'll apply sort of in different scenarios to, again, kind of supplement what a tenant may do in consideration of terminating their lease early. Yeah, I think that's actually, I'll turn it over to you, buddy.
Hey, thanks, Jason.
You're welcome. It's my
yeah, one last thing I wanted to kind of mention about the 83.63 is that you'll see the statute is broken into two parts. Now, when we were using this fairly recently, that wasn't the case. You had that part one that allowed you to, and I know we're kind of getting off the topic of flood disclosures, but it's just related in terms of what you're going to be seeing in terms of your practical available remedies. But you were initially that the tenant could terminate the rental agreement, immediately vacate the premises when there was this, substantial casualty loss to the actual property, as Jason mentioned. And then the second part was they had to comply with Section 83.493, which is the return of the security deposit. What it did not have was that part two. And so that actually created this closes a fairly significant gap where there was a lot of back and forth with landlords, is that the tenant was not per statute required to be giving an opportunity to collect their belongings when it was safe to do so, meaning that some tenants were holding off on terminating the lease because their stuff was still in there. And this kind of closes that gap and makes it clear that, yeah, you can immediately terminate the lease. And even after you terminate the lease, they've got to they still, number one, still there. They've got to comply with the security deposit provisions, and they do have to allow the tenant to come back and get their stuff. So that actually is kind of a big deal. So even though that's not directly related to the new changes that we're seeing here, that is a change in the law. And I think something that I think will, again, shorten some of the arguments that we have to have with landlords going forward. All right, so back to our remedies under the mobile home statute. One, you'll see, first of all, again, this mirrors very closely the remedies under the statute for regular residential landlord tenant. The big deal, A, is that, you know, when the mobile home is damaged itself, that's generally what we're ending up seeing, and that, in addition to the personal property, can be counted toward the loss. Again, they're required to the mobile home park owner is required to repay anything that was paid in advance. And again, you'll see that last section, of course, that, well, it doesn't really affect if they were already behind on rent or anything like that. The mobile home park owner's rights are retained with respect to that. One nice thing about this is that 83.63 that we just went over for residential tenancies, there was no mere provision for mobile home under the Mobile Home Act. So this does provide some right that the mobile home park or mobile home owners were renting in a park just really didn't have before. So this is a nice way to get that. Hopefully, assuming the disclosures, again, this is all dependent on disclosures not being properly made. But if disclosures weren't properly made, and they find themselves with these losses, hopefully this will be a nice way for them to be able to deal with that and deal with that general issue we see with mobile homeowners, where after a major flood or any disaster, they are stuck with that lot rent, which really does significantly impact their ability to recover. A huge reason, of course, is because if you're still obligated to pay lot rent and you need to live somewhere else, where is that money going to come from? And a lot of times we're seeing people who are in these situations, it's not like they were sitting on a huge pile of cash to begin with. So this can really, really be a big issue. So it's nice to see these things put in place. Now, I don't know if everybody else who was looking at this, particularly if you're looking at this for the first time, I certainly did. I kind of looked, it's like, well, that's it. If you don't disclose the flood that you knew was there, you can just get out of your lease and you don't have to pay any more rent. There's no like actual consequence for any of the losses, anything like that. None of that's going to be recovered. That's the case under these direct ones. We're going to talk a little bit more about that later, because while the remedies that are available directly under the statute, first of all, it's not as if they're insubstantial. Good remedies right there. They're going to be able to get out of your lease with some easier way than you might necessarily be able to get out of it under 83.63, because it doesn't rely on damage to the actual property that's being rented. It just, did you suffer a loss to your personal stuff? That's good. That's a good thing. But again, as we'll come back to later, one of the critical parts of all these disclosures is that they make the disclosures. And that can be used in a couple of different ways. Before I move on to that, I just want to go ahead and cover 718 and 719. The remedies there are a little more limited because, just like everything else in the statute, this was the existing remedy under both of those statutes already. This just added another disclosure to the disclosures that were already required when these sales took place. So as I'd mentioned before, these statutes look almost identical to one another. They just apply in slightly different situations, but this is the exact remedy under both of those statutes. It's in any contract that doesn't conform to the disclosure requirements. Obviously, the statutory language is a little different than that. So I've got my little brackets there, but it is voidable at the option of the purchaser prior to closing. So subsequent to closing, that obviously there's not going to be a voidability thing there. So the statutory remedy, again, is very limited in that circumstance. So what do we do here? We find out we've got all these new flood disclosures. That's great news. We're going to have more informed renters and purchasers and condos and co-ops. They're going to know how to insure themselves properly, and hopefully that alone is going to help alleviate some of the issues that we see in the aftermath of a disaster. It's not going to alleviate all of them, because even people who do know about flood insurance don't automatically become able to afford flood insurance. So we're probably going to see, even despite these disclosures, particularly if these disclosures are made correctly, a lot of people in that same circumstance regardless. But what about the circumstance in which you've got a landlord who either failed to disclose or specifically lied in the disclosure about the flood risk to a property. You get a flood that comes through, and they have a substantial amount of damage. Just getting out of their lease and getting any advance rent paid is probably not going to put them where they need to be, particularly if they weren't insured. So that brings us to this. These two remedies are the real immediate strength I see behind these statutory requirements. Is, I said, yeah, just the fact that they make them write it down gives us an in. So if they make that false representation to a renter, not only do you have the statutory remedy available, which again is fairly limited, but you have potentially these two as well. If they just completely falsely represented it, all you got to do is go to what you have under fraudulent misrepresentation. Probably familiar with that. Johnson actually goes into a fair degree of detail on that, in addition to setting those standards for the need to disclose not items that aren't readily observable. But what you have here, you've got a false statement concerning a material fact. Was this or was this is flood prone? Representer's knowledge that the representation is false. Again, maybe you don't have that in every circumstance, but that's what we've got number 2 here for. An intention that the representation induced somebody to act on it. I'm not going to tell you about the flood risk here because I want you to rent this property. And then the loss of their property because they relied on that representation. Pretty good. Pretty straightforward, I think, too. There could be some difficulty really improving the falsity of the representation at the time. Going to get into that in a little bit at the end here. But then you go down to, negligent misrepresentation. If you don't get to that point, even if the person who signed the statement or made the statement didn't really realize that it wasn't true, but they should have known through any kind of reasonable inquiry. We might end up seeing when we're talking about property managers, things like that. Did they actually ask the question of the property owner or anything like that before going ahead and just filling out this boilerplate, which we're sure to see. Again, negligence in making that statement because it was pretty easy to catch up on and see if there was anybody who actually had any of this knowledge. And then the intent to induce them, of course, they want them to sign the lease or whatever it happens to be. And then the injury resulting to the other party based on their justifiable reliance on that. Justifiable reliance is really the main difference between the negligent representation and the fraudulent representation. If it's outright fraudulent representation, their reliance doesn't even need to be justifiable. You don't have to go to that reasonable person standard or anything like that. You can just go, well, they lied and I believed them. Doesn't matter how crazy the lie was. I believed them and they shouldn't have written that down. Here, you've actually got well, that doesn't sound right kind of analysis here, but that's still going to be available, particularly if it's not a readily observable condition of the property. Sometimes, most of the time, it's really not. Particularly when we're not talking about these readily available or regular flooding incidents. Sometimes you do see that, and somebody happens to come and rent in winter when it's not raining. They'll find out pretty quickly that there was something that was observable if they came at the right time. It's still going to end up being justifiable reliance because at the time they couldn't tell that. That's going to be powerful, and that's going to open up again a lot more than just the standard statutory remedies do. I'm not even suggesting that these two are the only available, but these are the two that kind of immediately spring to mind when I see that. And this just sort of also to emphasize the importance is, look, the law is good. The fact that they have to make the disclosure is good. Don't box yourself into the statute itself. The fact that that actually has to happen at all opens a lot of doors for us. So, well, in the aftermath of our 2024 disclosures, I was a little like, it's fine. It's good that you have to do that. We already had Johnson v. Davis, and at the time we also didn't have that requirement to outright disclose whether or not, hey, did you know that there was a flood coming? Luckily now we do. And one of the advantages of that, by the way, is with respect to Johnson v. Davis, is because you are statutorily obligated to make that disclosure, you don't have to go through the analysis of the observability of the defect or anything like that. As if they knew, they violated it. So there is a little bit of a shortcut too there. So that's a nice thing. We're getting a lot more tools in our toolbox generally. Overall, I'm pretty excited about this one. As far as the actual content here, we're going to start winding down. Did want to leave a little bit of time here at the end for questions, but I did want to leave us with some thoughts I have on this one. Again, one of the reasons that I wasn't quite as excited last year about those flood disclosures, again, any disclosure it's good disclosure, more is better. But with these, particularly with your landlord tenant obligations, these are ongoing relationships. When we're talking about the disclosures from last year, you do the sale, the person moves on. Hopefully you can find them after the fact if you're in a situation where you have to do that. Here, pretty easy to find the person that you are actively renting from generally. So you actually have a defendant that you can get a hold of. That's one thing that makes me a lot more excited about this. The second thing is, particularly when you're dealing with landlord tenants specifically, is there is a big asset sitting right there, the land or the building being rented out. So when you're going through the analysis of the sellers, if the seller made a misrepresentation, they took the money, they bought another house, you can try to fight with them over a lien. It's going to be in Florida a pretty big uphill battle because we're dealing with homestead protections, things like that. They may not necessarily have a whole lot of other lienable assets. So even if you can find them, even if you can sue them in the context of a sale, what is your actual likelihood of recovery? You still might be out in the cold for the most part. Here, when you're dealing with bad disclosures from landlords, they are sitting on that land that they rented to you. Generally, that's not going to be homestead property. And even if you can't get cash readily available out of them, all it takes to record a judgment lien is to take your final judgment, record it in official records. Obviously, it's a little bit of more technicality to it than that, but it's really, really easy to do and turn that into a lien against all their property in that county. So that gives you a more powerful enforcement mechanism than you may necessarily have in the context of the sale, in the context of the violation of the stuff we were talking about back in 2024. And so just like I was saying before as well, the fact that they have to write it down, make the disclosure is itself a big deal. Even if there were no remedies prescribed in the statute, it's still a big deal that it makes them do that. Because if they don't, for example, we have the misrepresentation, either fraudulent or negligent, available. The other thing that I kind of want to emphasize for everybody, and this is kind of an important thing for us in disaster relief and probably just in practice generally, is a lot of the times when you're trying to undertake the actual practical analysis of a client who comes to you with an issue like this, you're going to need to find out facts about that property that aren't going to be readily discoverable immediately without going to litigation. So you don't necessarily have the opportunity to get into formal discovery or anything like that. It matters to be able to talk to people in your county, your city, your municipality, whatever it may be. In the county, for instance, after last year, you may remember if you watched that CLE, Jason was constantly harassing Pinellas County's floodplain manager to find out how to get off of Jason Island. That was a valuable relationship too. What's the problem, Jason?
It was harrowing.
But the point is though, is that we had developed those relationships. They knew who we were. So we were able to talk to the county, have those conversations, get that information. And just like everything else in disaster, you don't want the first contact you have with these people to be when you need them. Make those relationships in advance, get to know them, make those phone calls, go to whatever meetings that you can. If you want to have get any more information about that, first of all, we do have those Doug calls. We talk a lot about outreach, things like that there, but there are a lot of resources available if you are interested in getting more involved in this sort of thing. And then lastly, we've been rambling for a little while, so what are you guys doing? How's your weekend? It's lunchtime. You guys eating anything good?
Help us out, Jorge.
All right, so
John's
feel free to
treading
use
water.
the chat and ask all the hard questions right now. So I see Kathy, she has her hand up. Kathy, I'm gonna bring you off mute. If you wanna ask a question, let me go ahead and find you here. I don't know if it was inadvertent though. But if anybody has a question, if they don't want to drop it into the chat, they want to come off mute, I can bring you off mute. It's a little bit easier. So I will share the CLE code in a second. And Kathy, I'm gonna bring you off mute. I don't know if it was inadvertent, but feel free to come in. Not sure if you are there.
It was inadvertent. Sorry about that. Great job, Jason and John, though.
All
Thanks,
right,
Kathy.
so
My favorite question so far.
yeah, let me drop the CLE code here just in case. One sec. All right, so that's the CLE code. It's 2509627N. I've also been, I see a hand up. I've been compiling all these statutes like with the links, so I will include that in the materials as well. I've been dropping them into the chat, but I know it's not always easy to follow. I will include instructions if you're interested in joining the disaster umbrella group or the housing umbrella group. If you're civil legal aid, I will also include instructions as well. So Brooke, I see your hand up. I'm gonna see if I can bring you off mute so you can ask your question. Let me see. Here you go. And Brooke, you should be able to unmute yourself and ask your question.
Okay. Can you hear me, Jorge?
Yeah.
All right. Thanks, guys, for hosting. A really good job. So I have a quick question. My understanding is that, again, it's great that caveat emptor doesn't apply to residential, but my understanding was that it still applied to commercial leases. So I guess my building off of that is that with the Davis case, like do these disclosures still apply even in the situation of like a commercial tenant where like my understanding again caveat emptor still applies to commercial leases, but what about in this subset? It sounds like maybe for floods that there might be a way around it. I mean, obviously we don't get a ton of it, but sometimes we do get, maybe a low income individual with a that owns like a small business and this might come up. So I'm just kind of curious about the intersection of those two because they seem to kind of be at odds with each other.
Yeah. So yeah. Unfortunately, your instinct on that is correct. All of these with the rentals, they specifically apply to residential tenancies. So our commercial business owners, and like you say, we do run into a lot of people with small businesses. Just commercial leases are assumed under law, as you're aware, to be sophisticated and able to engage in these arm's length transactions. And unfortunately, no, this does not take into account all of these small business owners, family owned businesses that really do not have that level of sophistication. But
Gotcha.
yeah, those disclosures under all these disclosures we just went through, residential only. Commercial is still caveat emptor. You are
Okay.
out there on your own.
Okay. All right. Well, thank you for just clarifying then.
Yeah, it's a great question. And it's great for you to bring this up because I think last year we actually asked the question, what about mobile home parks? What about renters? And so the answer was no. And that's the prequel. I'll share I didn't want to drop the link to that YouTube video in the chat because it might start playing and it might be distracting, but it will be in the materials again if you missed it. John and Jason did a great job of recapping that statute. So sometimes asking these questions is what can lead to these changes. I was tracking this bill early on, and originally the mobile home parks were not mentioned at all. So somebody must have asked or somebody must have noticed, and it was also added on, right? So thanks for the question. Anybody else has any other questions? Or you can use the chat, you can raise your hand, you can use the Q&A. Let me double check.
Sounds like part 3 may be commercial properties next year. So we'll just wait for that.
So I kind of went with a Star Wars kind of topic with the floating disclosures strike back. So do we have to do like Return of the Floating Disclosures for that part?
Yeah, it's a trilogy. Yeah, that's right. That's correct.
All right. One
Return of the
favorite that I
Disclosure.
will ask of everybody here, like if you stumble upon any of these floating disclosures on how they look like on paper once this law goes into effect. So if you talk to any tenants or mobile home park tenants that enter into a new agreement after October 1st, and you stumble upon these disclosures, feel free to share these with us and the Disaster Umbrella Group. We can start sharing these as templates and what to expect and how do they look like. Are they actually abiding by it? So something that Jason and John mentioned earlier, like if think about an apartment building or a mobile home park, if they fail to disclose this to one tenant, they will likely fail to disclose this to everybody. So this is an opportunity to make sure that there's systemic impact sheet. So
Yeah. One thing on that subject too that occurred to me that I thought about, but I think forgot to add it to the slides is one other thing that if you encounter a client who this disclosure hasn't been made to, in a park or in an apartment complex, they're probably not the only person in that complex that they failed to give the disclosure to. So when this happens once in these circumstances, you're probably going to see a fairly large body of, particularly if you're in legal aid, it's a nice thing to keep in mind if you're trying to keep your numbers up, potential clients that are going to be in a lot of the same circumstances. So this could be a big deal in terms of that and getting that sort of more mass assistance as well. All it takes is one person to ask from an entire complex and find out they have been improperly disclosing to everybody. That could be.
And this is where the disaster umbrella group comes in. Even also the housing umbrella group comes in. We have a great community. We all share information. So, you know, if anybody notices this type of behavior and has information to share, that's what we like to do. So I want to take this opportunity to thank John and Jason again. I think they mentioned like last year when we planned part one, we actually had to postpone it because of a hurricane. So I did not want to even mention that this year around. Like, okay, we were able to scale it, you know, 1 week prior to the law going into effect. So it's not an easy thing to do, doing a CLE on a law that is about to go into effect. So we're delving into the unknown. So we really definitely appreciate all of your expertise and knowledge and willingness to educate us on these matters. So a big thank you to John and Jason and everybody that joined us here today. If you were not unable to join us or register, make sure to share the links to the recordings with other colleagues. So any final words before we wrap up the sequel and start maybe planning the part 3 next year? All right, so I guess we're gonna wrap it up and hope everybody enjoys the rest of the day. Have a good one.
You guys just email me what you had for lunch afterwards instead. So thank you very much, everyone. Please don't do that. Don't encourage him. He's a lot to handle. Please just don't listen to him. Thank you, everyone. Take care. Log off immediately, John. Please log off.
You got it. I can't find the button.
It's on the bottom right.